So here's an interesting question from Taylor, Law Self-Defense Platinum member Taylor. Writes, Minnesota has statute 609662 entitled Shooting Victim Duty to Render Aid. And we're going to look at the statute. I pulled it up. Basically, it kind of says that if you discharge a gun and you injure someone, you have a duty to provide aid. And if you don't, it's a criminal offense, could be a felony. Also, if you're a witness to someone being shot, you have a duty to provide aid. Now, this is an odd kind of statute because normally under American law, unless you caused the harm, you don't have any duty to provide aid to anybody. You don't have a duty to rescue, especially if it would put you in any kind of jeopardy. So that's the standard, the legal standard. You don't have a duty to jump into a lake and save someone from drowning. Now, maybe you might, if you like pushed them off a pier, you created the danger, then you would have a duty. But if you're just a bystander, you don't have a legal duty to provide aid to anybody. So this would seem to run counter to that. I will say the statute is quite ambiguous, really. It strikes me as intending to be applied more to kind of an accidental shooting situation rather than a self-defense shooting situation. And of course, those are completely different situations. But I'll pull up the statute in just a moment. Let me finish the question here from Taylor. If we, as the shooters, are trained in trauma care, how do we articulate the perceived danger and not physically lay hands on the bad guy? I can hear the argument, he was bleeding out in front of you. How was he a threat? I've always told my students not to get close to the bad guy, like kicking the gun away as we see on TV. Now that I have learned about the statute, I want to give my students the right advice. So there's a big difference between the accidental shooting scenario where you're handling a gun and it goes off. Frankly, if that happens, it's recklessness as far as I'm concerned. And you shoot somebody unintentionally versus a self-defense shooting. Because in the unintentional shooting, presumably the person you shot wasn't threatening you. They're not a danger to you. So there wouldn't really be any reason not to provide aid. Providing aid does not increase your jeopardy. They were never a threat to you in the first place. That's very different than a self-defense scenario where presumably you only shot the guy because he was trying to kill you. And if he was trying to kill you, why would you close proximity to provide care? When the professionals show up on the scene, EMS shows up on the scene, they don't go near that guy until law enforcement secured the scene to make sure it's safe. So if the professionals wouldn't do it, why would you do it? That's the argument I would make in court. And can prosecutors make this argument? Oh, not only did you shoot that guy, but you just let him bleed out. You didn't even try to help him. Yes, they can. Of course, they can say anything. And they make that argument quite commonly, actually. But again, the question is not can they make it? The question is how damaging is it likely to be and how effectively can your lawyer mitigate that damage? In a genuine, otherwise lawful case of deadly force self-defense, the person you shot was trying to kill you. It's not reasonable to expect that you would close proximity when he still could be a threat and to try to provide aid. But let's take a look at the statute because it is kind of interesting. So here it is. I pulled it up on Lexis. Oh, I guess I have to open up a different tab. Hold on. Where is my, here it is. Okay. So Minnesota, 609662, shooting victim, duty to render aid. First of all, you often get statutes from the legislature because making legislation is making sausage, right? So there's lots of debate and compromise that happens. But in the very first section here, definition, as used in this section, reasonable assistance means aid appropriate to the circumstances. So what's appropriate to an accidental shooting is not the same as what's appropriate to a self-defense shooting, and includes obtaining or attempting to obtain assistance. Well, does that mean calling 911 satisfies this statute? I would think so, right? You're obtaining or attempting to obtain assistance of aid from a conservation or law enforcement officer or from medical personnel. So that sounds to me like calling 911 would be adequate. And I do generally recommend you call 911. And when you call 911, you ask for police and an ambulance, not just for the guy who got shot, by the way, but for you. You may be injured and not even know it. So right away in that first paragraph, it's clear this is not an absolute mandate that you close proximity to provide aid to this person that you've shot. Then the second section here, this is duty to render aid. This is for if you've shot somebody. A person who discharges a firearm and known or has reason to know that the discharge has caused bodily harm to another person shall immediately investigate the extent of the person's injuries and render immediate reasonable assistance. Again, and reasonable assistance is defined in that first paragraph as arguably meaning even calling 911. And if it's an accidental shooting, you should do this, right? If there's a mishap at the range or a gun somehow goes off in your hands and, I mean, I had a case where a client accidentally fired their gun. They were handling their gun. They were, I can't remember now if they were dry firing and they didn't clear it effectively, but the gun was in their hands. It discharged, went through their window and through the garage door of the house across the street. And they called me up. They're like, what should I do? And I said, well, the first thing you should do is go over there and make sure there's not somebody bleeding out. I mean, you're going to get in trouble for this. And he did get in trouble for it. Not super serious trouble, but he had a court appearance over it. Lost his concealed carry permit for a while. But how much worse would it be if your neighbor had been struck by the bullet, was bleeding out in the garage, and he died only because you didn't go check? So in any kind of unintentional shooting, I think this is only reasonable. In terms of even a self-defense shooting, again, if you can satisfy the statute simply by calling 911, which is what the first paragraph suggests, I don't think it changes anything. If you violate the section, if you fail to do these things, it could be imprisonment for up to 2 years. That's felony time. Fine of $4,000. If substantial bodily harm results, which is what would happen with a gun, imprisonment for, death would result in 2 years. Substantial bodily injury would be not more than a year, but a year is still generally felony time, and a $3,000 fine. Or otherwise, if not even substantial bodily injury, still same penalty. Or if you're a witness. So if you're a witness who witnesses the discharge of a firearm, knows or has reason to know that it caused bodily harm, immediately investigate, render immediate assistance. And here it would be basically misdemeanor level time. So I don't think the statute changes anything. I think it's feel good. Now, I will note when you look at how the statute has been applied, first of all, it looks like it's, some form of it was in 1991. It was updated in 2004, I guess. But if you look at its application, there's no case law. There's no court decisions, appellate court decisions, reviewing the application of the statute. So I always say, if all you do is read a statute, but you don't read the court decisions, the appellate court decisions applying that statute, you don't really know what the statute means. Nobody does. Because the statute doesn't mean what the plain language might suggest it means, and it doesn't mean what the legislature might have intended it to mean. A statute has no effect in the real world by itself. A statute means, in the real world, how an appellate court interprets and mandates that statute be applied to real people in real cases. So until that happens, we don't really know what it means. And there's no case law here on the application of this statute in its own purpose as bestowing a criminal conviction in a sentence. There's a couple citations here. They're both to the same case, but these are not a criminal offense under the statute. These are instances in which a sentence for some other offense was escalated, an upward departure from the normal sentence, because they didn't meet the requirements of this statute. But it's not a conviction under this statute. So for all I know, no one's ever been convicted under this statute. So hopefully that answers that question. I don't think it really changes anything at all. 2A, self-defense, $10 super chat. Thank you very much. Says, I have been following you for about 12 years. That would be about since the Zimmerman trial. Minnesota duty to render aid has always been an issue for local trainers. It's a non-issue. A 911 call is enough. Yeah, I would concur based on my reading of the statute. If you call 911, it satisfies that. And again, the normal American legal standard is you don't have a duty of care if you didn't cause the harm. So I'm not even sure that statute would pass constitutional muster. But in any case, it really hardly matters. A 911 call is sufficient. Even if you just shouted for police, I mean, that's seeking to obtain care.